And we're going to start with our second panel, second and last. And we're going to move forward with the new technologies, freedom of expression, internet governance, etc., media, for the next hour and a half or 2 hours. So I would like to thank Marcel Leonardi for being able to be here with us today. Also, Dennys and Rafael. It's a pleasure to know that more internet-related centers are blooming. So congratulations on the baby InternetLab. So we're going to go in the same way we did in the first panel. I'm going to give the word to Marcel, then Dennys, then Rafael, and please do feel free to raise your hand and ask questions. This is a very informal event. We do not have to follow a strict protocol. So if anything comes up during the talks, please feel free to raise your hands and ask your questions. Okay? So Marcel.
Thanks, Monica. Good afternoon, everyone. It's a pleasure to be here. First, a disclaimer. I work for Google in Brazil as public policy director. And I also teach here at this very institution. I have a course called Direito Digital, or Digital Law, and it's a post-grad course to give an overview of what happens in the digital world. I came from academia, so I'll be forever in academia, I would say. So I'm at Google now, but who knows? So the idea of this talk is to give a perspective on some of the challenges that not only Google, but pretty much any online company faces regarding what is probably one of the most debated topics, still is, despite the law, in Marco Civil, which was the idea of liability regarding third-party content. So the idea of the talk is to explain first what that is, why that is controversial, and how that ties into freedom of expression, how that ties into the discussions that we have, and why that is a huge opportunity for students in general, especially in the light of the competition that was previously mentioned here. So the key aspect that I wanted to emphasize is the idea of an intermediary. What do we call this very concept of an intermediary in this online world, so to speak? So an intermediary is basically any agent, any company, any institution that provides some sort of service online. So when you, for example, do a search on Google, Google is the intermediary that you're using. So if you have your email on Gmail, Gmail is the intermediary. If you watch a video on YouTube, YouTube is the intermediary. So a huge discussion that stemmed in the past was the idea of to what extent these intermediaries should be held liable for the content that their users upload to those services. So in other words, is YouTube liable for the contents of all videos that users post there? Should it be? Under what circumstances? So before I delve into how the Brazilian law ended up going the way it was, some background history is warranted. I promise I won't go back to the ARPANET days, don't worry. Nobody wants to read about ARPANET anymore, including professors that end up grading papers, so bear that in mind. In any case, I guess one of the key landmarks of the topic was way back in 1993, 1994, when the United States was discussing what would be the correct regime for liability for third-party content. And probably most of you have seen that movie called The Wolf of Wall Street, right? What you might not know is Stratton Oakmont, the company that was portrayed in that movie, was also has a very interesting tie with this with cyber law cases, which basically was one of the very first cases in which the liability of an intermediary was established due to something that the user has posted. What happened back then was somebody uploaded to a BBS back then some nasty comments about Stratton Oakmont. And Stratton Oakmont, I mean, they were probably true given what we saw in the movie. But nevertheless, Stratton Oakmont didn't like what they saw. And basically, they decided to sue not the user, him or herself, who was responsible for the content, because it was an anonymous person. It couldn't be identified. Basically, they decided to sue the intermediary, the BBS. Back then, the United States court that decided the case ended up deciding that it was a case of strict liability. So the BBS was, yes, it was liable for whatever the user had posted. And that would be a very troublesome development for the then fledgling internet for a very specific reason. I mean, we're talking in the Jurassic era of the internet, probably, right? We didn't use any of those services that we use today. But basically, the concern was, to what extent, if this precedent was going to be applied to the rest of the online world, can online services really bloom? So in 1996, the United States Congress passed a law called the Communications Decency Act, or CDA for short. The idea behind the CDA was to criminalize any kind of content that was harmful to minors. The idea was that if you were disseminating, if you were publishing any kind of content that was harmful to minors, you could be held liable and as a user. And the idea was, so the user is liable, but what about the platforms that are going to be used for that content to be disseminated? And that it was created a specific section in this law called Section 230, Section 230, that basically said that no publisher, no interactive service, that was the language they used back then, should be considered the editor or the author of the content that was posted by a user, so that there wouldn't be any liability from the fact that you were an author or an editor. That was called the safe harbor provision back in 1996, as I said. An interesting development happened in which the rest of the Communications Decency Act ended up being considered unconstitutional by the US Supreme Court. And because, why that happened? Because that very idea of criminalizing content that's harmful to minors was considered too broad and too vague. Basically, what's harmful to minors? I, for one, let my kids watch Woody Woodpecker, and given the political correctness world that we live in, maybe someone should call social services, I don't know. But the point is, because it was way too broad and way too vague, the law was struck down with the exception of Section 230. And Section 230, as I mentioned, created these safe harbors for intermediaries, saying that they could not basically be held liable for any kind of content that users posted using online services, with a few exceptions, of course. Needless to say, not everybody was happy with the idea of this broad, how can I say, safe harbor for the intermediaries. 2 years later, in 1998, the US enacted what is now known as the Digital Millennium Copyright Act, the DMCA, which established a notice and takedown regime for copyrighted content. So the idea was that you could send a notice, and that was probably addressed in the previous panels, and then you could get that content removed. And also with safe harbors, as long as the platform followed through with whatever the takedown was about. If the takedown had all of the prerequisites fulfilled and everything, then there wouldn't be any liability for the platform. So the idea was that for general content, we wouldn't have any liability in the US because of CDA 230, with a few exceptions like criminal stuff. And for copyright content, there wouldn't be any liability as well, as long as providers complied with the notice and takedown regime. In Europe, though, back in 2000, a broad directive was enacted in 2000. It was the directive 2031 from the European Commission, from the European Union. And basically what happened there was a very broad obligation was mentioned, in which intermediaries could be held liable for whatever content their users posted, as long as these intermediaries had, one, prior notice of what was going on, and two, they had a reason to believe that the content was infringing of some sort. The way that the directive ended up being interpreted was, who exactly can notify a platform that this content is illegal? Just somebody that claims to be a victim of some online wrongdoing can do so? Or do you need to have some kind of judicial authority to step in and say, hey, I did analyze this content, this looks bad to me, you have to take this down? That was up to for the European courts to decide. And through the course of the years, they decided that usually a judge needs to be involved, at least as far as saying, is this content defamatory? Is this content harmful? This kind of scenario. For the more objective scenarios, and the cliche example is obviously always child pornography, there is no need to even discuss it. I mean, there's no possible exception under the rule of law for any kind of freedom of expression argument or anything along those lines. So usually a notice is enough to take that down. Now, having said mentioned this very brief scenario of how it was in the US and Europe along these years, Brazil actually lacked any kind of legislation of that sort until this very year. What happened was our local jurisprudence, our courts, ended up deciding what exactly should be happening. The way the courts started deciding this in Brazil was as follows. At first, they decided that strict liability should follow. The idea was if you have a platform, nobody told you to have a platform. So basically, it's all your fault. So anything that anybody publishes in your platform, whatever that platform might be, is your responsibility, is your liability. You're going to pay damages no matter what. Obviously, that's not very good news if you are a platform owner. So basically, they started to fight these court orders and trying to make the theory that it was not strict liability, but subjective liability stick, and they got it. At the end of the day, after several years of discussions, basically the Brazilian Superior Court of Justice ended up creating a kind of a precedential case in which they basically said there's no strict liability in these scenarios. The platforms are not supposed to be controlling this content, at least not proactively. And basically, the liability regime that we should adopt is as long as the moment the platform is notified of the existence of some sort of illegal content, then this platform has to act to take down or in some way deal with that content. Otherwise, then it could be held liable for whatever the user posted. So going back to my previous example, according to the Brazilian jurisprudence, if you uploaded a video to YouTube back in 2007, I would say that if the case was judged around 2008, YouTube would be held strict liable. Nobody told YouTube to create this platform in which people can upload things at all times. If that was the exact same case back in 2013, last year, for example, then YouTube would probably be held liable if, after receiving a complaint from, for example, a victim was claiming, for example, defamation or harmful, some kind of harm to his or her image, whatever, basically, if YouTube failed to comply with the complaint that the person sent, then it could be held liable. And that was not exactly a very good way to make policy for these platforms or even for the user, especially in the name of freedom of expression, for one very simple reason. What ended up happening was basically if the rationale was anybody can complain and order content to be taken down, what ends up happening is, well, then your complaint has the exact same power as a restraining order, as a liminar, as we say in Portuguese, right? So basically, that was explained to courts over and over, and a new theory emerged which aligned with the discussions around Marco Civil. What the current law in Brazil says, thanks to Marco Civil, is basically the idea that platforms can only be held liable if they fail to comply with a content takedown order. The idea being, rather than we making sure that anybody can take content from the online world at any time, basically a judge always has to step in and order the content to be taken down. Having said that, that does not mean by any way, shape, or form that platforms have their hands tied and have to wait for a court order to take content down. As long as any kind of content is still against the terms of service, is still against whatever policy that platform adopts, content removal can still be done on a voluntary basis. So often I get asked this question, especially in classes. So is it useless now to notify platforms and ask them to take content down? And say, no, it's still very useful because you don't know what kind of policy they're going to apply. If they give you an answer, say, we won't take this down because we don't see a violation of any policy, then you can take that to court, and if a judge agrees with your theory, that content will be ordered to be taken down. So I guess a way to summarize this is content takedown in a forceful way. You can only force a platform to take content down via a court order, but you can always ask platforms to take content down, and they might comply via any kind of other communication, letters or complaints or whatever, what have you. And that was obviously, I gave you all of the conclusion because it's already in law, so it's no surprise. But the discussions around that were really fascinating, and that's really where part of the value of this debate is, because one might be tempted to assume that just because the law now says this, then the matter is settled. No. Whenever we go to these events, people are always saying, so is there a way to circumvent that rule? How can I create some sort of exception? And one, the law has already created one exception. The law specifically says that is the general rule, with the exception of whatever exceptions have already been created by law. 3 exceptions already exist under Brazilian law. The first is child pornography. That has been the case since 2008, according to what we call the Child and Adolescent Act, ECA, Estatuto da Criança e do Adolescente, that basically says in its Article 241A that whenever a platform is notified about the existence of child porn, it has to take that content down immediately. There's no questions, there's no other way to handle it. The second thing is the very Marco Civil on Article 21 said that any kind of sexual imagery between adults, but without any kind of consent for it to be published, as what's been popular known as revenge porn, should be taken down immediately. The rationale is kind of similar in the way that, well, you really don't need a court order for that. I mean, there's no freedom of expression exception, blah, blah, blah. And of course, it has to be unauthorized. Of course, for those of you who enjoy those acts in an authorized manner, Marco Civil is not going to really help you. Jokes aside, the third exception has already been created by Brazilian electoral law. Brazilian electoral law since 2009, it basically says that any kind of irregular political advertising, any kind of political messaging, if it's deemed to be illegal, then platforms have to take it down once they get notified of the judicial order. So it's interesting because Marco Civil ended up adopting as a general rule the same rule that the election laws had already established back in 2009, even though it's slightly better language. Why do I say that? Marco Civil also says that any kind of order that says that you have to take content down needs to specify the exact location of that content. So you can't have orders like remove all photos of Marcel in a red dress. I would like to do that, but unfortunately I wasn't able to. So I have to specify all of the URLs, all of the locations in which that content needs to be found. But wait, the content I'm trying to fight has gone viral. It has like 1,000 URLs. Do I have to nominate each and every URL? Yes, you have to. And of course, you can do that on an ongoing basis, depending on what's going on in the lawsuit. But basically, the idea is that no general content takedown orders can be issued. They're actually invalid. The law says so. The second thing, which should come to no surprise for absolutely everybody, is Marco Civil also exempts copyrighted content from these rules that I just said. As a matter of practicality, then all platforms are keep doing the DMCA removals with the notice and takedown regime, rather than trying to create its own thing. Of course, when and if Brazil adopts a new copyright legislation and changes that model, perhaps to a notice and notice model, perhaps to a notice and takedown specific model, things might change. But for now, because copyrighted content was exempted from this rule of Article 19 of Marco Civil, basically there's nothing that can nothing has changed in that area. But as I mentioned that I was going to talk about the debates, which were the most interesting part during the law. So when Marco Civil was proposed, the actual rule that existed was the complete opposite of what I just said. Basically, Marco Civil was was proposed with the idea that any kind of content could be taken down by request. It was a notice and takedown regime for any kind of content. And the running joke in Congress during the time was that any kind of political websites would be blank, because basically politicians would be constantly notifying each other. And if you guys are following up close the debates that lead up to the runoffs this next week, you probably know exactly what I'm talking about, right? I mean, obviously everybody is complaining about something, and then no content probably would survive. But exaggeration aside, then it was a very ongoing discussion on what exactly should be the extent of those things, how exactly could freedom of expression from the users be helped with the protection of these platforms, why that was an important issue, and so on. And basically, after lots of debate, Brazil adopted made its choice. The Brazilian legislation made its choice, and it's, as I said, as a general rule, forced content takedown can only be obtained via the court order, and failure to comply with that court order will lead to liability on the part of platforms, with the exception of the cases I already mentioned. What are the challenges now, though? For one, there are some proposals already to change Marco Civil. One of them really strikes me as problematic is the idea that, as I mentioned, that Article 21 has this exemption for revenge porn, for the immediate takedown of content that is harmful to these kinds of scenarios. One proposal that has showed up is the idea that any kind of content that harms human dignity would have to be taken down upon notice as well. And I ask you, what exactly is that? I mean, I have seen a decision, and not really picking on any particular state. Not sure if we have any cariocas in the audience, but I remember seeing this decision from the State Court of Rio de Janeiro, basically saying that a broken blender was an insult to human dignity, and basically warranting damages because of that. So when you give such a broad possibility of content takedown, that's what worries me. So I think that Marcos Aviu ended up picking a good choice in the balance of those things. And if more exceptions are needed, yes, the law can and will create them. But my point is, it's very hard to establish from the get-go what is the correct balance between these. As far as the Brazilian tradition goes, the legislation did shock a few people, because usually in matters of liability, especially civil liability, we tend to go more towards the strict liability standard. But because the internet has this different way of operating, so to speak, I mean, the editorial control is completely reversed. When you try to publish something in a newspaper or on TV or on the radio, I mean, no matter how charismatic you might be, you're not going to be at the front page of the news just because you want to. But you can be your master of your own YouTube channel, of your own blog, of your own space in the online world. And nobody is going to control that beforehand. So the dynamics are very different in that sense. And that's why, not only in Brazil, but across the world, the whole idea of how liability for those scenarios was going to be treated was considered in a different manner than traditional liability. Having said that, I'm not saying that is the perfect and all and best solution of all time. Other things could and probably will be suggested. But as far as trying to strike a balance, so far, to me, it seems that we aimed in the right direction, especially given our tradition, given the new challenges that we are seeing worldwide regarding freedom of speech. Google has always been asked to say its opinions on the European decision on the right to be forgotten, for example, which I'll obviously leave to the debates. I'm not going to, I need to keep all these people in the audience for later, so I'm not going to say anything about that right now. But the point being, the story of Marcos Aviu around those that theme was probably one of the key victories, not only of users themselves, because basically they have all the incentive that they needed to keep publishing, keep posting, trying to keep their messages online, but also for what we call some matter of legal security, not legal security, legal. There's a proper way for this, legal. It will come to me. Tentando falar segurança jurídica in English. Certainty, thank you. Of legal certainty for platforms and for entrepreneurs, in the sense that now they know exactly what the rules are and how, if they are not liable for that kind of user-generated content, they also have tons of other obligations. So, for example, there's data retention, there's the need to try to help authorities to investigate whoever committed the wrongdoing. So I think we managed to strike an interesting balance that is consistent with Brazilian law. I'm not saying that is the best example for the world, and it's interesting because when you go to these international forums, people usually say, hey, Brazil wants to export Marcos Aviu, what should we do? I mean, is it really such a good thing to copy? And they say, well, the process was very interesting because after all, it's kind of unheard of when you have like this legislation being proposed as a public consultation process, open to any kind of citizen to comment upon and so on. Never mind the political process that happened, the traditional political process that almost obliterated the whole thing later on. But the content itself of the legislation, that I have to be honest, is nothing particularly new. I mean, the protection of platforms, the protection of freedom of speech, data retention, disclosing user information, and all of the other details that Marcos Aviu has regulated is not exactly new. I mean, plenty of legislation, similar legislation around the world that deals with those topics. Anyway, I think, and in conclusion for now, I think that part of the reason that this theme is so interesting is it comes up all the time. Why? because as you would probably see in cases that you study, not only as part of the moot court competition, but also as part of the real life, as we like to call it, basically these discussions come up all the time. So does it matter that the content has different authors? Does it matter that it has been uploaded to different platforms? Does it matter that one of these platforms is within the jurisdiction of Brazil and the other platform is not? Does it matter that that content has been republished by a user who has no idea that is infringing in the country of origin, and so on? So basically, there are endless questions to these debates, and that's why it makes it so worth researching and so interesting. Thank you.
Thank you, Marcel. I would like to move on to Dennys.
So, good afternoon, everyone. My name is Dennys. I'm here representing InternetLab, which is a new think tank in internet and technology that we founded here in São Paulo. It's very hard to speak after Marcel. First, because he's very entertaining, and second, because he covers all the issues. So I'll try to be very brief and just focus on what's left for us. And I'm going to make a few comments on things that I consider important, and then we can open for the discussion after Rafael also contributes. First of all, I want to talk a little bit about the importance of having a court order for the content to be removed, which is the rule that the Marco Civil has established. As Marcel said before, the Marco Civil, there was a big uncertainty as to whether OSPs, online service providers, could be held liable for content, for third-party content. And that used to put these companies in a very uncomfortable position. When they received a complaint about a content that should be removed, what should they do? Should they comply with that complaint and take the content down, or should they wait until the judge is asked to see whether that content should be removed or not? And if the judge ends up agreeing that that content should be taken down, then the platform could be held liable for not taking it down earlier. So when that happens, the platforms and the OSPs are put in a position where they are the ones making decisions about the contents that have to be taken down. And that is problematic in a number of ways. But the most important, I think, is these platforms are not the legitimate parties that should be taking these decisions. When you post contents online and there's the freedom of speech of the people is involved here, platforms are not the most adequate parties to take decisions about what contents violate rights or that should not be there, like online or available to the other users. So the judges are, in that regard, much more prepared and much more legitimate to take these decisions. So a judge is the one who is the correct or the most adequate, the judiciary, the most adequate institutions to receive these requests and balance the rights in question and decide. If not, if the platforms were liable, not only were they not legitimate to take these decisions, but also they could end up being overprotective about contents that are posted in their platforms. So if I am a platform and I can be held liable for the contents that are posted in my platform, what is probably more natural to do is that I'm going to be more protective because I don't want to have trouble in the future. So I'm going to start to overblock things that come up as troublesome. So, and that is also problematic for freedom of speech, because if you put the burden on the platforms, then you kind of give them a more sort of a right to be more protective, because in the end, they are the ones who are liable for that content that is posted. So in light of that importance of having a court order to remove the content, I would also like to talk about the way the judiciary is dealing with this request for removal. It is true that it was a victory that Marco Civil demanded that only a court order can be the way to force a platform to take down a content, but that is not enough. If we take a look at the way the judges are receiving these requests, and if we conclude that the way they are looking at these requests is very sympathetic to the request for removal, that is also a problem, because it's not enough to give the judges this power if they're not using this power right, if they're not taking the freedom of speech of people into consideration when they're agreeing with this request for removal. So that is a very important issue, and I think the judiciary has to be followed very closely to see whether this victory of the Marco Civil is really making a difference, is really something that is valuable for freedom of speech here in Brazil, and that's something that we are willing to do and consider very important. Lastly, I wanted to talk a little bit about the way the platforms comply with their own terms and conditions regarding the posts, the content that are produced by third parties. So when you post in a platform, and you don't need to wait until you have a court order for that content to be removed. You can notify, and each platform has a different way for you to report and ask for some content to be removed. And usually the platform is the first instance that will take a look at that content and determine whether it will voluntarily comply with that report and take it down, or whether it will wait until the judge to see whether it should be removed or not. And in that first instance, one thing that is interesting to think about is that there is no right, or there is no way for the user who posted the content and the platform that decided that the content should be taken down. There is no right for this user to demand that that content be available until a judge, for instance, decides whether or not it should be really removed. So I think this is an interesting discussion if there should be such a right, because you are in a platform and that platform made a lot of investment to create that atmosphere, and that platform might have its own terms of its own vision for that platform. There are some platforms that are more, I don't know, family-oriented because they want some kind of advertisers to be there, or they want to create a different atmosphere, a more family-oriented atmosphere. There are some others that are more libertarian, and that's something that it's up to the platform. But on the other hand, there's been a lot of activists and a lot of people that end up relying or depending on these platforms to express their political views, and if these terms and conditions are too strict and a lot of content is being removed in this first instance, there's also a question as to whether there should be a right of these users to question the removal, the voluntary removal of these platforms. So I think these are three comments that I had to add, and I'm looking forward to the discussion.
Okay, thank you. Good afternoon. My name is Rafael. I'm from the Law, Internet and Society Nucleus from University of São Paulo. And just as Dennys mentioned, it's quite hard to speak after Marcel. So I'm not going to talk about the legal regime of liability, just like Dennys talked a little bit. I'm going to pose some fundamental questions about what, in my opinion, what should be the research agenda on freedom of expression in this topic. So basically, I think the fundamental problem is that Marco Civil, the internet, is just a law. And you cannot change law and you cannot change legal culture only with law. So we need to reframe our discussion to the Brazilian legal culture, and we need to think seriously, what is the role of freedom of expression in our legal culture? I'm going to present you one argument about this. Back in the 50s, one famous sociologist called Thomas Marshall, he wrote a paper about how Britain developed their legal regime and their rights. And he had this thesis that in Britain, they first had the civil rights revolution, and they posed the freedom of expression as a fundamental civil right. Then they had political rights, and then back in the 20th century, they had social rights. And in Brazil, we don't have the same pattern. We don't have this same evolutionary development of rights. If you read José Murilo de Carvalho's book, which is called Cidadania, Longo Caminho, he published back in the final of the 80s, he looks back to Brazilian history, and he identifies that we didn't have civil rights movements at all in Brazil. And the first thing we really had was, first, social rights with Getúlio Vargas regime back in the 30s. Then we had dictatorship that lasted 24, 25 years. And then we got back our democratic regime. So we re-established our political rights. And now we're finally developing our civil rights. So Brazil is a really different country. We need to look to the discussion about freedom of expression and human dignity in our legal culture. And we don't have a research agenda about Brazilian legal culture. So I think we should look seriously. First of all, just as Dennys mentioned, we need to monitor how the judges think. So we need to look back, and we need to see how they interpret this collision between freedom of expression and human dignity. And we have plenty documents and materials to do that. We need to look at dogmatics. What is the role of dogmatics in Brazil? Because we have a different system from the US, that what the academia says doesn't matter so much. They have the common law system based on judicial decisions. And here in Brazil, a lot of the power to produce the legal discourse is based on academia. And academia certainly influences how judges think. So we need to look how the civil rights scholars in Brazil, how they interpret this collision between freedom of expression and personality rights, just how they call it. The third thing, we have 1,000 law schools in Brazil. And we need to understand how they're teaching the young scholars about this collision. If you take a look at a law school curriculum, they have 3 years of civil rights, direito civil. And they discuss for 2 years personality rights, direitos da personalidade, and dignity rights. And they construct this legal discourse that the first thing we need to protect is the human dignity. And this is a really powerful legal discourse. And what is the role of a democratic debate in law schools? Can we identify this vision that we now live in a democratic society and everyone has the right to produce information, to share information, and to build their own knowledge and perceptions about political discourse based on their own views? I think we don't have this legal culture and education culture in Brazil, and this should be one way to proceed. We need to investigate this in law schools. We can take a look at law schools' curriculum and how they're teaching civil rights in Brazil, and how this collision between freedom of expression and human dignity takes place. So for me, it's really sad when I go to Google Scholar and try to search for legal papers, books about freedom of expression in Brazil. I can find only 10 or 15 master's degrees or doctoral theses about it, but we don't really have a big production, especially in law schools, about this. So it's completely different from the US, that you have the whole tradition about the constitutional law, the freedom of expression as something that you cannot change, and even in Europe. And this is especially worrying when you go to the right to be forgotten debate, because Europe has consolidated this view that we need to balance the freedom of expression debate with human dignity, and people have the right to be forgotten or not to be indexed in some searches engines, just like Google. I just want to reaffirm one opinion that was made by an Argentinian legal scholar called Eduardo Bertoni. He's from University of Palermo, and he said that the right to be forgotten is just offensive when you consider the Latin American history, because we just got back from a dictatorship when we had a censorship structure created by the state that was complied with legal private companies. And if we assume that the right to be forgotten is something that we should pursue, probably we would have politicians and people trying to hide what happened in the past 25 or 30 years ago, and people wouldn't have the chance to know what happened and what is the Brazilian history or what is the Latin American history. So we should be really careful when we talk about the right to be forgotten in here, because we have a quite young democracy, and people are just beginning to develop their own sense and capacities of building their own personality and how they see the world, how they read the news, and how they develop their own opinions. So one thing that Eduardo Bertoni proposes, which I think is quite interesting, is that we should use the same structure that we have in the propaganda and marketing business. So when you go to Google and you search for, I don't know, a place to go or someone else, they usually put an advertisement just behind or nearby the website that you wanted to go. And Bertoni proposes that we should use the same structure. So when you have something that is offensive, like a website that is telling a story that is not true or maybe offends someone, people should have the right to develop their counter-argument, and this counter-argument should be placed in the search engine. So we wouldn't have private censorship created by Google, but Google should be obliged to show the answer provided by the person that felt offended. Do I make myself clear? So when you have something that you find offensive, you have the right to prove that that version is wrong, and the people who will read will make their own opinions. So you have the fact and the counterfact. You have narrative A and then narrative B. And people should have this capacity and ability to form their own opinion in a democratic system. We should believe in people's capacity. Private censorship is just the wrong way. You cannot omit or put information and data in an empty space or something you cannot locate. I think this is a worldview, a view of society that is basically wrong when you consider that in a democratic system, people have their own capacity to evaluate things and form their own perceptions. So this is my small contribution to this debate. Thank you.
Thank you, Rafael. Dennys. Rafael, I was especially struck by your comments on a freedom of expression agenda. I'm really glad to see young scholars here, such as Clarissa, who is actually pursuing that in her PhD at USP. And hopefully we will have more students and more scholars looking towards these themes. I have one comment to make, and I would like to hear you on it, and then we can open for questions. One thing that actually is a real problem regarding content removal, especially in a globalized world where companies no longer have territorial barriers to how and where they provide their services, is actually the jurisdiction issue. We recently had the secret case in Brazil, and I would like to hear my colleagues on this topic. How do you see the jurisdiction problem being faced? I mean, you have Marco Civil applying to Brazil, but you know the company is not located in Brazil. So in order to make that court order that will eventually come out effective, I would have to execute it elsewhere, and in internet times, that might just be way too long. So one way courts are looking at it are, you know, they're just taking the harsh and the more restrictive decisions, such as let's ban the app, right? And that raises several concerns regarding freedom of expression, and I would be very interested in hearing your thoughts about it.
Well, that's very interesting. I really like jurisdictional questions because I think they really represent what the internet is all about, especially for lawyers. What are the main challenges that we have? And regarding content removal, I think it's very interesting because this approach, the one that is going after the whole app or the whole website, so is usually the best solution that some countries find when they cannot go after the platform because the platform is not in their country. So we have a number of examples. Like in Turkey in 2007, YouTube was blocked for 2 years because of some videos against Ataturk, which is a very traditional, the founder of the republic that cannot be insulted in videos and stuff. And YouTube actually denied to take down those videos because they were uploaded by people who were not in Turkey, and Turkey wanted the content to be removed, so YouTube was blocked. And we can see this approach in various other examples. Indonesia banned recently Vimeo because there were some music videos where there was content using like nudity, and for the Indonesian standards, those were violating their pornography laws. So I think this is a question that doesn't have a satisfactory answer. And but for content removal, it's really really something that's very problematic, because in one way, these platforms are sometimes fighting for more freedom of speech. So if you take the Twitter's example, they were a platform that resisted for a long time, I think, expanding to other locations because they wanted to be so protective for freedom of speech that they were in the United States, where that value is very protective. So all these orders from other countries would have to face the American jurisprudence to actually determine Twitter to take down some content or to give users account information. So I think it's problematic because different countries have different stances as to your freedom of speech. So in Germany, for example, there are some speeches that can be banned, but in other jurisdictions that is not the case. So when you're dealing with these different standards and these platforms act globally, it's a problem for the platforms that have to comply with all these laws, but also a problem for the countries that wanted their laws to be complied, and also a problem for the users who might end up not having access to those platforms because one content violated a law.
So back in 1990-something, maybe 1995, 1996, there was a diplomat in Pakistan that actually wrote a book called The Law of Cyberspace, An Invitation to the Table of Negotiations. You can still probably find that book online somewhere. His proposal was that any kind of content that violated Pakistani law would allow the Pakistani authorities to extradite and judge within Pakistan whoever had published that content. So the idea of trying to apply local jurisdiction outside of one's own country is not really new. What's really more problematic is to what extent companies should or should not comply, as you guys mentioned. So I guess part of the solution is transparency. That's why pretty much all of these companies in the online world, they publish these transparency reports, because at the end of the day, if it's really not up to the companies to decide whether something is legal or illegal, whether something ought to be removed or not, they're supposed to comply and be done with it. Then it's up to society to show that that compliance is not, should not, or ought to be tolerated. It's really hard to dismiss the cultural aspects of it. I mean, when we think about the Western standards, everybody's pretty much in agreement that we should not censor the internet, that people are free to partake and try to access any kind of information that they want. And then you remember the likes of Saudi Arabia, in which the very population is the one feeding the central authority regarding what kind of filters the country should have. So the very citizens of Saudi Arabia, they help the government censor their own internet, and they're happy with that. So it's really hard to pinpoint what the solution should be. What I personally believe, that's not really Google's view, that's Marcel's view, please, is it's probably a really pipe dream try to imagine global laws on the merits, or like on substantive content. Maybe we can have some sort of collaboration regarding processes, and then that's probably a way forward. So let's say you want to take something down within Italy for some reason, and then the Italian authority issues this order to a Brazilian company, for example. Then as technology advances, and then we use more tools like geolocation, like IP addresses, and any other kind of tools that allows us to target precisely which countries have access to which kind of content, then maybe we could start doing that. Because as of right now, what happens is, let's take the right to be forgotten cases in Europe, for example. The search engine delinks the name of the person from the specific URL that he or she has complained about within the Google point something domains within Europe. Now, what prevents somebody from going to do google.com or even google.com.br and do the exact same search and find the content that was censored? As of today, nothing. But the point is, what if national governments start demanding, I don't suppose that could happen in Europe, but you never know. What if they start saying, no, you can't offer nothing but the localized search engine version to the citizens of Italy, for example? Then if an Italian citizen tries to go to google.com, then he gets his very nasty message saying, no, you're supposed to only use Google Italia. So basically, you can't search outside your own border. And that's not the way the world operates at this point. So it's really hard to say how companies are going to comply with that. There's ongoing pressure to comply on a global level, and then that brings us back to the problem that Jonathan Zittrain identified that the slowest ship as the slowest ship in the convoy, which is basically the idea that you have to adopt the stricter standard to whatever you are doing. So imagine trying to do, as you said, if the images of some kind of music video were illegal in Indonesia, I don't think that the images from our own carnival in Brazil would resist those kinds of laws. And then what you risk is adopting this minimum, the lowest common denominator, and actually doing the most restricted version of the online world. And I don't think that Brazilians would disagree that they don't really want their freedom of speech to be anything to do with the standards from Indonesia, as the Indonesians don't want their standards to be anything to do with the German, and so on and so forth. So it's really hard to pinpoint what the solution should be, because the internet created this mess of jurisdiction. And I mean, if I can make a joke here, when we were back in law school, when we were all studying international public and private law, and we thought, what good does this serve me? I mean, this is really complicated. I'm not sure if I ever face a case that deals with those issues. Well, here we are. Those lessons are way more important than you ever imagined they would be.
Okay, I would like to open up the floor for further debates and questions.
Hi, good afternoon. I would follow the tradition and say that it's very hard to follow Marcel as well. Also about internet, I have a student, and I'm going to make her really uncomfortable right now, but she's at home watching us, and she wanted me to ask Marcel, we know that Marco Civil is an important regulation of internet, but in face of the culture of self-exposure in Facebook and etc., the users kind of waive their fundamental right to privacy in social networks as Facebook's and etc. You think that state still need to regulate and protect more the users of internet? Or if the state interfere more, will we get to, I don't know, the risk of becoming something like the USA? This is my first question from the student. I would also like to, can I just, one more. I would like to direct my question to the second panelist about platforms that, if I understood correctly, some of the platforms to protect themselves from content being taken down, they sort of directed their, I don't know, their design to make it more family, I don't know, family-oriented or approachable to families. But what if we got to a stage in which every website or every platform would kind of either turn neutral or find a way that it would seem neutral and we wouldn't have this ability to reach the platforms? Would it be prejudicial, or would it be even better, so that not the platform were reached and kind of suffered from a disadvantage, or and just the content was directed and taken down?
Want to get started? It's up. 6 up.
I can. So with regard to the second question, for me the point is, regardless of what kind of atmosphere the platform wants to create or emulate or have, when they design their own terms of service, they are empowered to do that because they created the platform, as if, or as just like a restaurant that might say, well, you cannot come to this restaurant wearing shorts. I want everyone to be dressed up, and I want to create this atmosphere in my restaurant that is a fancy place. But my comment was more, when you have platforms that are so popular or so important that people find them as the main source for political activity. For instance, if I am an activist and I want to do a campaign, I really want to do it on Facebook, for instance. If Facebook is very strict about some of their policies and they remove content that could not be removed by a judge would actually say, oh, that's okay, that's their freedom of speech. But that's not okay in that platform. And my question is whether there should be a right for someone to question these terms of service and say, well, actually, I have a freedom of speech and I want to post this picture and I want to have it online and I want to use your platform for that. To what extent is that right a legitimate right to be protective? And what happens to the platform that wanted to create an atmosphere and that wants to attract a certain group of advertisers? Sometimes there's been a lot of debate when there were some groups protesting for Marcha das Vadias and Não Mereço Ser Estuprada, which were two movements for women's rights, and they used a lot of nudity in their as a form of protest. And Facebook has a very strict policy with nudity, and it ended up blocking content that was not blocked elsewhere. For instance, there are some examples of people who scanned the pages of newspaper and then when they uploaded it on Facebook, Facebook blocked because it was nudity, and Facebook has a very strict policy with nudity. And it's also hard for a platform to deal with this content, like what is nudity? In India, someone in a bikini might be considered like nudity. Here, it's somehow acceptable. So how can the platform deal with this different cultural standards? So I think that my comment was more of to provoke the thought more than a proposal. But I wanted to comment on that power of the platforms to remove content voluntarily that could not be demanded to be removed otherwise.
So back to her first question then, I guess it's twofold. I mean, she mentioned self-exposure, and she mentioned to what extent the state should still be regulating the internet, especially the Brazilian government. So on self-exposure, the question couldn't come on a better day. I mean, today for us that came from the University of São Paulo Law School, it was Peruada Day. Peruada Day is the street carnival in which people go wild, go crazy, and nobody wants to tell us the stories later on. And I, for one, am very happy that during my days, I'm not that old, but I mean, it's a different world. I mean, we for once, cameras had film, and for two, you could actually not only buy the photos from the photographer himself, but you could also, for those very nasty photos, you could actually buy the prints, o negativo, as we say. So you deleted it from the source. Today, it's impossible. If you go to the street carnival, basically your photo is already in all social networks, even whether you like it or not. Well, you were there in the street, so. But in any case, I think that self-exposure is something that the state has, the government has to take a look upon, and basically a part of Marco Civil that's often very forgotten is Article 24 and onwards, which basically deals with what the government should do about internet policy. If you go to Article 26, I'm going to do a translation on the fly here, it actually says that the constitutional duty of the state regarding education in all levels of teaching includes the capacitation and the integration of other educational practice for the safe, conscious, and responsible use of the internet as a tool for the exercise of citizenship, the promotion of culture, and the technological development. So in a way, you could say that Marco Civil even created the duty of the state to actually, I wouldn't say teach people how to better use the internet, but at least to put in the regular school curricula, so to speak, the idea of safe internet use. And safe in what sense? I mean, it's the things that us parents do with our kids. It's basically the idea that what is common sense, or ought to be common sense for most people, like don't post things you don't want other people to see. Don't give out your address online. Be a responsible person. But self-exposure, it's really, I mean, if I could say something, it's probably more a matter of psychology rather than law. I mean, what motivates people to actually self-publish and expose themselves? It's usually the constant need of human attention in a very attention deficit world. I mean, it's even funny how nobody has a bad day on Facebook, right? I mean, nobody ever posts how they got a flat tire, how they got all caught in the rain, how they were robbed. It's all about, see my beautiful vacation, see this medal I got, see me swimming, see all these smiles, blah, blah, blah. So, of course, it's a way that people use to actually try to bring attention to themselves. And in that sense, I mean, law can regulate only so far. What I think that can do, and that's probably a debate that's going to show up eventually, and it ties with the second part of the question, should then the government regulate the internet even more? I think the regulation could be to what extent companies have a responsibility to actually provide tools to manage that kind of content that you publish. Not only Google, but Facebook and other companies have tools within their own servers, within their own services, that actually provide some sort of level of control. To what extent that data that is collected is actually going to be used, to what extent that data can be deleted from the services, to what extent you can control that information. But that also only goes so far. It only goes so far regarding the content that you yourself publish. What others have published about you is usually what really is the problem. So this day you go to a party, you cannot avoid like somebody with a cell phone somewhere, it's sticking it in your face. Oh, let's take a picture, let's do this, let's do that. And that's usually fine. The problem being to what extent that's no longer something that people want, and to what extent that challenges the current cultural and legal traditions. I mean, Rafael mentioned this in a very interesting manner. I mean, Brazilian culture, the Brazilian legal culture has not really given a huge thought about it. What we see usually online are issues like, just because somebody uses a pseudonym, judges say it's anonymity, so we have to take it down, no matter that the content was actually valid. Oh, Article 20 of Brazilian Civil Code protects the image of people, so this photo was published and authorized, let's take it down. Wait, what about the journalistic value that it could have? So all of these cultural challenges that we are going to be facing in the legal culture, they will come eventually not from jurisprudence, not from the tools. It will come from each and every one of you who will end up developing papers and publishing comments. And one thing that's really ought to be said here, I think, is we still, given that cultural tradition of law, we still pay way too much deference to jurisprudence in this country. It's almost like, oh no, because the Superior Court of Justice said this, then it has to be the truth. Oh my God, the Supreme Court said this. These guys make mistakes all the time as well. So it's up to us to criticize and actually debate this. But back to self-exposure, I don't think there's really a solution that the law is going to provide. It's really a mix. As for more state regulation, the state can probably intervene and demand that companies provide more tools for citizens. But as for more regulation, I mean, the very reason that Marco Civil was needed was to bring the legal certainty that I mentioned. It wasn't really because people wanted to control the use of the internet or something like that. And I think so far, we actually ought to have the law take a little time. You know, nobody has even seen what are the effects. I mean, it came into effect at the end of June. We barely have a few months ongoing. People already want to change it, try to find the loopholes, try to modify it. I mean, let's wait and see how that happens. So that would probably be my suggestion here.
Just a side note on that. It's one thing to have 70, 80-year-old judges faced with internet lawsuits, internet-related lawsuits, and not being able to fully understand how the internet works. And that's something that we must address. But I've recently been approached by a few high schools in São Paulo. And the board of directors of these schools, they're really concerned about how the kids are exposing themselves on the internet. And I recently went and talked to a few students in one of these schools. And what strikes me the most is that young kids, so my children in a couple of years from now, they're not really that worried. But the school is really worried. So the school wants to know what kind of action can they take, because they sort of want to take the role of maybe of the parent or of the child, should be a little bit more mature, and it should be concerned about the drunk picture it's posting or the nude picture it's posting. It doesn't really have a lot of consequences right now, but it will have in the future. And a lot of people ask me, well, can we create norms within the school walls and or firewalls? And so I feel that a lot of people are turning to law as a way to regulate problems that are really beyond the law. I mean, you need to teach kids to be more responsible. You need to teach children that their actions have consequences. A lot of the children who were actually using Secret for bullying, and the bullying was enormous. I mean, you know, you had children who were really, really hurt by bullying, and they weren't able to defend themselves because they had no idea who was posting those comments. These are kids who have no idea of what, you know, they have a false sense of anonymity in the internet. They have no idea of the consequences of their actions. So I see that people are trying to transfer to the law the role that parents or maybe schools should be taking on of, you know, teaching more responsibility. So I think that should also be taken into consideration. Lawrence Lessig has a famous TED Talk regarding copyright law and mashups. And when he talks about what our kids are doing, he says, well, the law can't really stop people from doing it. The solution that the law finds is criminalizing it. But the fact is, we're not going to stop posting videos on YouTube, right? We're not going to stop remixing. Maybe is criminalizing, is turning everything that this generation is doing into something illegal? Is that really the answer? I don't think so. So I think we really ought to be looking at different approaches and maybe talking a little bit more openly about responsibilities. That's part of education, right? That's one way forward.
Can I just add?
Yeah.
About the self-exposure? I think it's really important that we talk about educating young people or the children about the responsibilities that they have. But I happen to be a columnist at a parenting magazine, even though I don't have kids. But one of the things that we wrote about was the parents themselves have to be educated about these issues, because what you see sometimes that parents post a lot about their kids, and since they're born and until they're, I don't know, 10, and when this kid is 10, there's already a whole life, a whole digital heritage that this parent, that those parents created for that kid, and that those are pictures of him, those are moments of him that are now shared and recorded forever. And so there's also, I think, some work to be done with how parents deal with their kids' lives as well, and how much exposed those lives are, and all of these questions.
Well, good afternoon. I have a question, and I think it's for Marcel, but maybe other people can help me understand this better too. It's about providers, online providers' engagement in defending those contents that are questioned in the judiciary. Because I think that maybe, as we don't have a tradition to discuss civil rights, those providers don't have like incentives, and they don't have someone who could construct those arguments for them in order for them to engage in those contents defense. Sometimes we tried, some time ago, we engaged in a small research about online providers' liability before Marco Civil was approved. And we noticed that sometimes when the original author of the content was also included in those lawsuits, the sentence the judge issued was really bigger. Like sometimes you had like 4 or 5 pages sentences, and this was the majority of the sentences, because only the online provider was the one which was included in the lawsuit. But when you had the original author, you had like a 9, 10, 11 pages decision. And that might suggest, I don't know, I'm not sure, because we don't have access to the complete lawsuit. We don't know how the parties engaged, how they put their arguments. But this might suggest that when the author is there and he can like defend what he said, you have a discussion of a better quality about the content, about what liberty, freedom of expression really means. And so I just wanted to know if you have some information about how online providers are really engaging or not in this like content defense.
You raise an excellent point, which to what extent online providers should actually not only defend their users' content, but also even communicate with them that there's some kind of content removal order or something along those lines. And I think that Marco Civil did another thing that was really correct. Basically, it says that when you have any kind of content takedown, you have to notify the user, unless the judge said you shouldn't. I mean, the whole idea, the real reasoning behind that is that the user can then come to court and actually say, hey, you know what, this needs to stay online and this is the reason, blah, blah, blah. That doesn't really help. That doesn't really happen much in practice, though, because a user might as well say, "Well, I'm happy with Google defending me, and I want to pay a lawyer for that. I don't know who to seek. I don't know what to do," and so on. But that's probably the exception. I mean, I can speak for the experience that I see inside Google. Google is the kind of company that will fight if it believes it's within their users' rights to the Hague court in Prague or whatever it takes. But most intermediaries, they really have little incentive to actually fight back. I mean, usually what potentially gives you less trouble? Just complying with the first court order that you get, or even maybe just with some user complaint, or actually fighting all the way through, paying the attorneys, filing the lawsuits, being in the public eye, be perceived as a company that doesn't want to comply with the first decision and so on. And then you have the small victories that make all of that pay off. So Monica mentioned, for example, the secret case. Secret case, what happened was because the secret app itself had no local representatives in Brazil, the injunction went directly to Google Play and Apple iTunes Store, right? Apple immediately complied. They didn't bat an eye to it. Google appealed the decision, and at least as far as it was the last time I checked, it ended up reversing suspending the injunction so that the app could be offered again. The legal reasoning was because it wasn't really truly anonymous, because you could always try to identify people via the IP address. That's not necessarily a detail. But this is something that each company chooses to do or chooses not to do, depending on what kind of backlash they're going to face. In that sense, at least within Brazil, I think that Marco Civil again struck a very important balance in saying that no liability can accrue to the intermediary unless it fails to comply with a court order. And even in that case, it's not an immediate. Some room to discuss the order. There's some room to appeal the order. When you, of course, when you are in a situation in which there's no way to defend the efficacy of the order, then it's a different matter altogether. But as far as I see from my colleagues in other companies, it's always a struggle, because usually judges think of their cases in a very atomized way. So this is the case of this lady who has this problem with Facebook, with Twitter, with Google. They very often, they very seldomly understand that whatever they decide in that small case might actually have implications for all of the rest of the other cases, not only within Brazil, but as how companies are going to deal with those scenarios elsewhere. Usually, when companies resist disclosing user information, they resist taking content down, it's not only because of the specifics of the individual case, but usually tends to be what kind of ripple effects that decision is going to have elsewhere in the world. Because if you deliver data with no court order to a Brazilian authority, what prevents China from asking the exact same thing? What prevents other countries with way less democratic regimes, to put it mildly, to actually demand the same kind of parity, so to speak? So in a nutshell, I would say that I can perceive Google as being very user-friendly, defending the rights of the users, to the extent that users actually thank us in public. You probably saw the controversy around the takedown, and they've already been put back up, videos from Porta dos Fundos, in which they made some fun of a political candidate in Rio. And basically, one of the comedians actually wrote an article in which he thanked the company for actually fighting out for the user. So it's those scenarios that make these policies make sense. But usually companies are, at least in Brazil, are always on the other side of the spectrum. They tend to be criticized for actually defending user content rather than just complying with whatever the court order used to be.
Can I just add again? I think that's very true. And I think that's another key element in that discussion is that usually the user who posted the content, apart from the cost of having a lawyer and so on, if they want to resist or if they want to defend themselves, they have to identify themselves. And usually, they do not be identified. So they cannot defend themselves because that would be useless to that would be harmful for them. So I think that in that scenario, the system in the United States, in some states, is very interesting with the DOE defendants, that you can actually give these users an opportunity to quash the subpoenas or to challenge these requests of disclosure of identities without being identified. So you can basically defend yourself anonymously in court, which I think is very interesting.
Just to add, I think this institutional arrangement in the US is quite incredible, but we would have a problem in the Brazilian Constitution regarding the Article 5 that says about anonymity, that it's not allowed. So maybe we could think about another kind of institutional experimentalism that in those cases, so imagine one simple case. You have a blogger in Maranhão. He's against the Sarney family, and he's using the blogger service to produce critiques on the Sarney family and the political regime in Maranhão state. And so Sarney family arranged the best lawyer and starts a judicial process against Google in order to remove the content based on civil rights like human dignity, honor, and all these kinds of legal discourse. And then if the person, maybe in your point, Clarissa, Google doesn't have enough incentives to fight in court and to discuss about if this citizen has the right to produce that kind of argument and if that is legitimate in our regime. So maybe you could create a mechanism that you would call the Defensoria Pública to engage in the process and discuss the content of the dispute. And this would not include the person. And this would be one kind of institutional experimentalism that we're not talking about, we're not discussing. And this could be another kind of legal regime in the country. So maybe we should produce a policy paper to legislative and make these suggestions.
I just wanted to ask and to add another point. Do you notice, I don't know if you have information about that, but maybe you do. When we take the decisions, like the court's decisions, they are really poor in argument. Like they say about offensive content and offensive content. I think there are no other more sophisticated arguments, and we don't really see an argumentative structure, like what you could urge for one position and then how you could deconstruct this position. We don't have this kind of argumentative structure represented in our decisions. So I just wanted to know if this kind of debate happens during the lawsuit. Like if parts like engage in this kind of arguments, if they are really trying to define and more specifically what is like injury, like injuria, I don't know how to translate that, and defamation, and what is like the freedom of expression limits, why is it important in a democratic system, like trying to build a system of rights, like in a manner that they can be, let's say, intelligible, one in the light of the other. Like if you have this kind of argumentative structure being built in these lawsuits.
So you raise another excellent point, and the sad reality is usually judges adopt a very direct approach, which is this content appears to harm human dignity, therefore I find it illegal because I said so. And this brings me the opportunity to raise this, which always brings some eyeballs to pop, which is when I was doing my PhD and I researched this specific issue, it struck me as, I mean, I thought it was wrong at first. It's the kind of thing that you face and you say, no, this can't be right. I did some bad research. I have to go back. Basically, but it wasn't. It was sadly true. One of the very first times in which human dignity was mentioned in Brazilian law was not in the Brazilian Constitution of 1988, which is always, people always claim to be the most important thing, blah, blah, blah. You guys remember the dictatorship times, the AI-5, Institutional Act number 5? In its preamble, it actually says that they were removing all civil liberties and suspending all constitutional rights in the name of human dignity. So it begs the question of to what extent these broad, vague concepts actually, what do they actually mean, right? I mean, outside of the rule of law, and basically not much. So what companies try to do is they do try to provoke those arguments when they try, for example, because usually the process goes as follows. Google or any other company will get an injunction, and the analysis of whether the content was legal or not has already been made, because we already are receiving the order to take something down. And that analysis is usually very poor. Usually, even if the plaintiff made a very good case, or usually they don't, but if they made a very good case of explaining why that content should be taken down, they usually go along the lines of, well, this is a harm to human dignity, the bottom line is this, and then judges adopt a very weak reasoning. And then we already start the process in a position of disadvantage, because we have to convince a judge that not only his reasoning was weak, but maybe he wasn't right in the first place. We try, and we often lose. I mean, out of the several electoral cases that we faced, I don't remember how many victories we had, but it wasn't many, because usually judges adopt this very binary rationale in which this appears to be harmful, therefore take this down. How to provoke that debate, though, I think it passes through the idea of what Rafael was saying. We need to provoke the Brazilian culture, legal culture, to change, because whenever we go to these debates, and this is probably one of the first exceptions, I would say, people usually say things along the lines of, no, how do we remove content faster? How do we protect human dignity more? The internet is full of abuse. This is all bad. So it's really hard to say how to change that. I guess it will take some time. I saw, not sure if Laura is still around, but I saw that Article 19 launched the campaign today, I think globally, to try to decriminalize, along the lines of what you just said, the very ideas of defamation, of injuria, of slander, libel, this kind of thing. Because basically the reasoning is these are only crimes because it's the way that people have found to make sure that nobody is always safe. I mean, you can always claim that something is defamatory with some very good arguments, right? So it's really hard to say how to change that, but companies are trying. I can tell you that companies are trying. To what extent the arguments are being accepted is a different matter altogether.
Okay. One final question, and then we're going to wrap up because there's another event happening in a little bit.
I would like to go back to the search outside our border. I mean, whenever I go to google.com, then I'm immediately addressed to BR. Yes. Yeah, so you would admit. And that's nice. And if you consider that most people don't go beyond the second page, you never go outside, and most people may not be aware of it, as I have myself noticed. And okay. I think you have already taken measures to self-protect yourselves. Self-protect yourselves is pleonastic, sorry, but and I wonder, I would like to know first how I do search.com.
Okay, that's very easy. Google.com/NCR, no country resolve.
And, sorry?
Google.com/NCR, no country resolve. Then no matter where you are, it's going to take you to google.com. There you go. But jokes aside, I get what you're asking. Basically, the idea is, if your IP address belongs to a range that is within Brazil or within Italy, within what country have you, you will be automatically redirected to the local version of the search engine. And I understand what you're saying, but I want to get out. I want to type google.com, but it drags me back to BR. So that's a way to do that. But usually, people not only do not realize that, the idea is, as you just said, people actually prefer the localized version because because it's in the local language, it tends to be more precise regarding what you are searching, this kind of scenarios. But it's possible. There you go.
Yeah, thanks, because now I'm going to try Google instead of ask.com.
No problem.
The other question,
I
want to listen to you about a case you might be aware. Unfortunately, the name of a journalist is very popular as a blog, but I cannot, his name now escapes me. But he was sued by one of the ministers, Gilmar Mendes, of the Supreme Court. And the allegation was offensive, etc. And along these years, I mean, virtually a decade, he has been, the journalist, has lost in every instance until the case reached the very Supreme Court. And he was demanded to pay 100,000 reais. So the poor journalist is broken. So I want to listen to you about this, but how the judge himself imposes such a big charge. Yeah, thanks.
So your question reminds me of that joke, what's the difference between the Constitution of the United States and the Constitution of this Eastern European country? Because both mention freedom of expression. Yes, but only the US Constitution guarantees freedom after the expression. So basically the problem is, and that's something that usually Article 19 and other NGOs that defend freedom of speech are always very concerned. Very big penalties, as you just said, very heavy penalty fines even within civil litigation, if you leave aside the whole criminal aspect of it, also have a very obvious chilling effect. I mean, why am I going to criticize the Supreme Court justice if that risks me having to pay 100,000 reais, as you just said? And the reality is it's a different problem altogether. It's not so much, I think, about freedom of speech, but if you do research it someday, what usually is the minimum amount of damages awarded to the common citizen in these moral rights cases versus what's usually awarded as damages in these cases in which public authorities, even judges, are involved, you see there's not exactly the same. They think slightly higher of themselves, I would say. But the way to fight that would be exactly, well, if a person really was abusive in his or her comments, how do you make sure that's some sort of remedy for whoever was offended? And I guess part of the reasoning should be not just not financial damages, but maybe what usually works best is make the person publicly apologize, in the sense that it's going to make her eat her own words, so to speak. Usually that has a much stronger effect than any kind of damages the person could pay for. Because let's think of the opposite side of the spectrum. Let's say you're very rich and you don't care. You can just say whatever you want and then you just pay these damages and that's fine. Usually this kind of remedy ought to find a balance. The reality is the internet already provides for that. If you've been offended online, you can always put up your own web page, your own blog, your own thing. And Rafael was saying that there's this proposal that Google, for example, from Bertoni, or other search engines could have like these the same kind of prominence for the reply, for the answer to the person to whatever offended her. So it's actually not even a new idea. An American scholar called Frank Pasquale also had this very idea that Google should have some kind of asterisks, like let's say there's this search result and there's this asterisk, kind of like a footnote, and that asterisk would lead you to the reply to that link, so to speak. It's very hard to operationalize it, to put that into practice, but I mean, nobody really found the correct idea how to solve these cases yet, because I mean, no, I'm not denying there's some bad content online, that something should be taken down, that something should be removed, but how do you do that without curbing legitimate speech? And there's many parts to that. One is decriminalizing defamation, which is like one of the campaigns of Article 19. The other is making sure that these penalties are reasonable, as they obviously weren't in the case that you just made. And third, to what extent the right of reply can be applied online? Should it be automatic? Should it have the same prominence? Should search engines play a role? And I guess the good news for law students here is it's all up for research. You guys have to make the suggestions and then see how that's going to be implemented.
Wonderful. I'm sorry, we have to close because the room needs to be cleaned for another event. But you are welcome to talk to us once we wrap up. Thank you very much for being here today. We have a lot of people watching the streaming online, so thank to the online viewers as well. And I hope we can move the discussion forward, and I hope you students can engage further in this type of research, right? Thank you all very much. Bye-bye.